as you've heard, has asked the Supreme Court to immediately reinstate its ban on travelers from 6 specific countries from the Middle East and Africa, citing terrorism concerns. The Justice Department argued last week that the federal appeals court in Richmond, Virginia, made several mistakes in ruling against the White House travel policy. For a look at different court scenarios, we're joined by attorney Byron Henry, who's based in Dallas. Byron, is there a possibility that the Supreme Court does not take the case?
Yes, if there's not 4 votes to grant cert, that means the Fourth Circuit's ruling would stand, and the case will go on to trial on the merits. Remember, this is a temporary injunction, although it's relatively permanent. I don't think the district court is going to change his mind on this case, but the temporary travel ban would stay invalidated for the time being, but that's assuming there's not 4 votes on the Supreme Court to take the case. There's no requirement that they take it. Right.
Okay. So then what happens if the Supreme Court does take the case?
Well, if the Supreme Court does take the case, the key inquiry there is whether or not there are 5 votes to grant a stay of the Fourth Circuit's decision, meaning the temporary travel ban would go into effect as President Trump initiated it, and it would be in effect while the case was being decided by the Supreme Court. There's not 5 votes to change the status quo and let the temporary travel ban go into effect. Then it would just be handled like a normal Supreme Court case being appealed from a lower court.
Is this largely hung up, Byron, on President Trump's remarks as a candidate about all this?
It's really been winnowed down to that, Gordon. It is basically a test of whether or not statements made, regardless of what the face of the order actually says or the text of the order actually says, whether statements by a candidate on the campaign trail can be used to invalidate an otherwise facially legal order. And that's really what this has boiled down to. The lion's share of the lower court's opinions have focused on President Trump's intent, and they have said it doesn't matter what the order actually says. We know he really is doing this out of religious animus towards Muslims. That is the linchpin of the challenger's entire case.
We're speaking with Byron Henry, attorney based in Dallas, talking about the potential of the Supreme Court taking the White House's travel ban. So judges have the authority to interpret intent?
Well, there are a few instances when intent becomes important, but usually courts, number one, defer to the executive. In other words, the president and Congress always get the benefit of the doubt in close calls because of their, you always assume that the Congress and the president is acting in good faith whenever they take actions under their constitutional powers. But secondly, intent's usually only an issue when there's an ambiguity or you can't really tell what the order or the statute means. In this case, the order is clear on its face that it only applies to 6 countries temporarily for 90 days, and the court is basically reaching out in an unprecedented way and saying that the president's campaign statements basically nullify the facially neutral national security reasoning given in the order itself, which I think the federal government did a good job in their petition, is basically saying you understand what this means. Don't just look at this with respect to President Trump and these really high-tension political times we're living in. Look at this as an opinion that can be used against future presidents in other national security rationales, meaning do we really want courts looking behind a president's decisions to campaign statements or surrogate statements or Rudy Giuliani statements on Fox News to determine whether national security is really at stake.
Weird scenario I'll propose here. What if he were to come out publicly and disavow all the comments he made about Muslims during the campaign and say, almost like an NFL referee, listen, after further consideration, I've decided to restate what I've said and clarify. And can that then be used in court in the White House's favor?
Well, it's interesting you say that because, first of all, the Department of Justice, in their filing with the Supreme Court, pointed to just that scenario in the speech that President Trump made to the Muslim world in Saudi Arabia and said if prior statements can be used, which, of course, the government argues they should not be used, but if they can, then certainly the best statement to rely on is the contemporaneous statement of the President of the United States that basically was calling on all Muslims to join together with the United States to fight extremist terrorism.
Thanks, Byron. Byron Henry, attorney based in Dallas.